Ladies and gentlemen, boys and girls, your long national nightmare is over. Welcome to the first 2026 edition of All Things Litigation Funding. My name is Ted Farrell from Litigation Finance Advisors, and I will boldly predict we have our best guest of the year live in our studio, Rebecca Berrebi. Rebecca, how are you today? Please tell everybody, to the extent there's someone who doesn't know, a quick introduction, then we'll get into it.
Sure thing. First of all, I cannot express how excited and thrilled I am to be on this podcast. It has been a long time coming, and I am just so happy to be here. So thank you very much. But so I can introduce myself, absolutely. My name is Rebecca Berrebi. I am a proud member of the litigation finance community, and more specifically, I am partners with Ted in Litigation Finance Advisors as a broker and advisor to everything involving the litigation finance industry. So what a thrill to be here finally. Thank you.
Well, you're welcome, and thank you for coming on. So I'm gonna follow form here. So we'll get into what you do and what we do at Litigation Finance Advisors and advisory, all that stuff. But this is one in the feedback that everyone has sort of found interesting. So I'm going to ask you this. What was the first litigation finance deal you either were aware of or participated in? Because that's sort of everybody's kind of jumping off point. So what was the first deal you saw or worked on or anything like that?
Sure. Well, I can tell you that before I started working in litigation finance, I had no idea what it was. So I really came into the industry. I sort of fell accidentally into the industry. As background, I originally started in the law as a private equity M&A lawyer. I worked at a firm for many years, and then eventually I went in-house as a lawyer to a private equity fund, doing sort of more standard private equity M&A deals. And I decided I really wanted to get over to the business side. And I had a call from a recruiter. It was incredibly fortuitous and pretty random, to be honest with you. They were calling me about a business side position at a fund that had just raised a dedicated litigation finance strategy fund. And I remember my first question was, what is that? What is litigation finance? And I learned more about it literally on the interviews. So when I went to the interviews, I was asking a bunch of questions. I was figuring out, okay, I understand what this is. From a transactional perspective, which is, again, the background I come from, litigation finance is not that different than a lot of other transactional financing fields, right? The strategies, the mandates, the economics are particular to these types of deals. But as far as a funding agreement goes, it's very similar to all the other types of transactional documents. So anyway, when I first got to working at a litigation finance shop, the first deal I ever worked on was an international arbitration financing. And that is because the fund I worked for focused mainly on those types of deals, which I will tell you is even more complex as in terms of a case as a lot of the other cases that we deal with, because it involved, many different jurisdictions. It involved complicated facts. It was a mining case. And mining cases are by their nature very complicated.
Well, mining itself is very complicated.
Mining itself is very complicated. I had to learn about how gold is mined, and ultimately I learned about a lot of other types of mining as well. But yeah, it was a fascinating first experience. And I'll tell you, this was back in 2016. And so the litigation finance as an industry was very fresh. And we were a group of very motivated, well-educated, smart people, but we really were making a lot of the transactional and deal points up as we went. There wasn't a lot of precedent for what we were doing. And that was a very exciting time.
Interesting. Well, you did forget one plug because you did work at the #1 feeder law firm for the litigation finance business, and that is self-proclaimed. Where did you work? I want you to say it.
I worked at Kirkland and Ellis in the New York office, but I will tell you, at that time in history, litigation finance was not on my radar. Right. And to be honest with you, I don't think it was on most people's radar at Kirkland.
Right. Okay. So you worked for a funder. And then I think, skipping ahead, I think you made the decision, unlike certain people whose funders closed and threw them on the street with a nice letter and paid them for 2 weeks and said goodbye. I think you actually left a funder to get into advisory and brokering. So I'm kind of interested in, what was it about this market that you thought there was a real need, and that you'd be, well positioned to step in and work in?
Absolutely. Well, as I mentioned, I went to the fund that I worked at in 2016, which, that's not a long time ago in the history of the world. But in the history of this business, it is a very long time ago.
Yeah.
And the industry looks very, very different. But even while I was there, which was from 2016 until 2020, a lot changed. I mean, even in 2016, 2017, 2018, to be honest with you, there were not very many funds doing this. There was not a lot happening in terms of capital available.
Right.
And on most deals, we did not see any competition at all. Right. And what ended up, I'm a deal person by background. And what ended up happening time and time again, this did not happen once, it happened regularly. We would start talking to a counterparty about putting together a deal. And maybe we would offer terms, or we would start considering and thinking about terms, and we would start discussing them. And the people on the other side of the table would look me in the eyes and say to me, are those terms fair? And I can tell you, as a deal person, that is a problem. When the other side is asking you if the terms are fair, that means they don't know anything about what's market or fair in the industry.
And maybe as business sense, it might be a bad idea to do a transaction that you literally don't understand what you're signing. Like, is that
1,000%?
Well, I could write a business book about that. That could be a whole nother book. Don't sign what you don't understand.
It's true. And in those days, we had to even kind of force people to get lawyers. Like, some of these plaintiffs wanted to do these deals without advisory. And, it was a mess. So after hearing this over and over, I really recognized that the users of litigation finance back in, 2018 to 2020, let's say, had no idea what they were getting into. And there really weren't a lot of ways that they could figure out what they were getting into, because there wasn't that much material. There were no podcasts like this. Right. And so they really were at a disadvantage, a big knowledge disadvantage. So while that was continuing on, I was also seeing on the capital side more and more money flowing into the space. There was more capital available than ever before, and the users were still completely ignorant as to how this all worked. And again, it's not because they were not smart or sophisticated people, but simply because this was a relatively new market and there was no way for them to get information on how it worked. And that was what drove me to the decision of, you know what, I'm going to go out there and I'm going to help the people on the other side learn about what they're getting into, help advise them on what the terms should be, what market looks like, what the options are out there for them, to make this process hopefully a little better, a little more efficient, not just for the users, by the way, but also for the funds, because it's a lot of work for a fund to educate a user on how this all goes down. So that's how I decided to start this business in 2020. And you know what? So glad I did, because I think, I was right. The users didn't know what they were doing. And to be honest with you, as the industry grows and evolves, I think a large part of the users remain in that position. I mean, the industry has evolved so significantly and so rapidly. It's very hard to keep up with what's going on, unless you're really in it on a day-to-day basis, which is, I think a significant amount of the value that we, Ted, bring as brokers is keeping people up to speed, because they have day jobs, right? The litigators are litigating. The plaintiffs are doing whatever, business they're in addition to following their litigation. They have no idea what's happening on the current, market. And we can really plug that hole for them.
Right. I think we were talking to somebody the other day, and you said something that kind of resonated with me, which was, for a claim holder, like there's some law firms that do this all the time, but for a claim holder, like a corporate, they will generally use litigation finance either 0 times or 1 time, right? Like the amount of corporates that have done it a bunch of times, which is, I think sort of makes a need. So, okay, well, so let's talk a little bit then. So that was 2016, and that was helping people, and I was doing a lot of arbitrations. I'm interested to hear, I kind of know it, but I'm interested for everyone to hear sort of, where the market is today and the kind of stuff, we're working on, and, where kind of things are going. So like, where do you see like 2026 and deals and kind of what's, floating around in the market, today?
Well, it is extremely different than it used to be, right? I always like to say that litigation finance kind of generically, like for the most part, started for litigators by litigators. And, back in 2016, it was kind of like, I'll give you, $10. And when you win this case, you return $40 million to me, right? That was kind of the general structure.
Right.
And
well, you mean 10 million for 40, not $10 for 40 million.
No. Oh, yes. Yeah. $10. Okay, you give me $40 back.
So right. Not 4 million X, 4X. Okay. Just making sure.
4X. Yes.
4 million X is good.
In those days, it could even be a lot more than that. But now
I was going to say something about Argentina, but maybe I just won't say that here. I'll leave that alone. That's fine. We'll leave that alone.
Right. Good idea. I got off track. Okay. So, but now, the structures are just so much more sophisticated. It's just wildly more sophisticated. And that's because so much more sophisticated capital has come into the market, right? It's not just for litigators by litigators anymore. It's also really sophisticated financial people who can run, models and figure out a lot more in terms of, predicting timing and interest rates and cash flows, and all of the more, sophisticated financial knowledge has gone into these structures. And there's a lot of different types of money that has come into this space, right? It used to be mainly sort of like equity style investments, meaning, I get a multiple on my return. Now we see a lot more credit style investments that include an interest rate. This is all pretty basic. But I think what we're seeing more and more of, and we have been seeing over the past, I would say 2 or 3 years, is a lot more portfolios, right? Getting single cases financed is harder than it used to be. Mainly because I think there's fewer capital providers out there that are willing to do that. That is not to say that that doesn't exist. We still do it, and it's still possible, but it's easier to bundle cases. It's easier to bundle both in the form of sort of like the mass tort personal injury style cases that are sort of thousands of cases bundled up into one, but also in the commercial space where it's maybe 4 or 5 cases bundled up into one. We also, of course, see that in the antitrust area, and we see it in the IP portfolio space where either, owners of IP have multiple patent families that have potential claims against a variety of defendants, or, where you have a law firm that has multiple patent cases that are with, different plaintiffs and different IP underlying these cases, and bundling those up together. And then forget about it. When we include insurance in these packages, right, it changes the whole structure yet again. Right. Sometimes it makes sense, sometimes it doesn't, to use insurance, but there's so many options out there.
Right. And so if a law firm, and I think that, when we talk about where the business was 10 years ago, it was largely we're going to take a binary risk on this case, meaning if we put out $10 million, we get a minus 10. So while that return seems, quote, expensive, I mean, it is appropriate for the risk. But I think a lot of what, we've been seeing in the market and frankly working on, I'm just interested for you to sort of share with people, is helping people structure transactions in a way that de-risks it and gives them an overall lower cost of capital. So from sort of like a high level, a law firm says, well, we might have this case, we might have that, if you could talk a little bit about how we might help them put something together that meets their financial goals. And at the end of the day, if the case is resolved the way they want them to, they're going to keep much more of what they worked for.
Yeah, absolutely. So, you alluded to this. In general, litigation finance, whether it's a binary risk outcome, meaning like an investment in one case or in a portfolio, in general, these remain risky assets. Litigation is a risky asset and more riskier than some traditional assets like real estate, for example. And therefore, the pricing on these deals is expensive. There's really no way around it. It's never going to beat a traditional bank loan amount, right? A traditional bank loan is going to be less expensive than a litigation finance loan. But the reason for that is because the litigation funders are taking big swings and big risks. Even when you can diversify an investment portfolio, it still remains risky. So the returns are never going to be low. They're always going to be high.
But they're also only going to come out of what you win in the case. So if a law firm needs $2 million to pay for experts, they can go to their secured line at Wells Fargo or Citi or wherever, but that money's owed regardless of whether the case wins, right? So it's like that's what you're bargaining for, and that's why you're paying the higher premium, because it really is just tied to the litigation, not the overall performance of the entity.
That's right. I completely agree with you. So, you're paying high returns because you're asking a fund to take pretty high risks, but it can be well worth it. The old days, sort of the traditional formula that I alluded to before, which is, where funds take a portion of what we would sort of call traditional equity, right? I'm going to take 40% of every dollar you make out of this case or these cases. And that means, day one, what you're going to make at each level of recovery. And it could potentially be limited when you use, in terms of recovery, when you use a credit style return where there is no, what we call equity kicker, which means that the fund shares in the back end up until, infinity. When you use an interest rate and you can still, as a law firm or a funded party, you can still make all the ups, all the equity return without having to share that with credit provider, which basically means if you think you're going to make a huge return, you are always better off with a credit style return where an interest rate is ticking, and at any moment you know exactly how much you owe based on the amount you have taken out. So one way to structure for those, and I think this is what you were trying to get at, Ted, is when we combine insurance against a portfolio of litigation. That, the insurance itself is not inexpensive to take out, but the cost that you can get when you protect some of the investment value from the fund, you can get a much cheaper cost of capital, which even with the built-in insurance premium amount can still lower the overall return that a funded party would need to pay a funder at the end of the day. So there are a lot of benefits to thinking about how you want to structure a transaction before you go out and seek capital.
But is it maybe as easy as certain smile and dial operations would make you think, we'll get you X insurance and Y dollars tomorrow, and it's that rosy? Is it as easy as maybe the cold callers would make it sound?
If it were that easy,
we wouldn't be on this podcast.
Doing it. And
we wouldn't be on this podcast.
That's right.
That's right.
Unfortunately,
I'd be asleep. I would be sleeping. I would be asleep.
Right.
I guarantee.
You would be taking naps or watching movies or whatever.
Right.
Or you would be playing hockey and I would be playing tennis.
That's true. That is true. That is true.
Yeah. So it's not easy. Unfortunately, it's not easy. These cases are complicated. These litigations are complicated. And as we know, law firm structures, when law firms are taking down taking down capital, there's a lot of complexity in how law firms get paid and how partners get paid. These are not easy transactions. They are difficult. Everybody involved would love to snap their fingers and say, okay, this is a great deal. We're all going to make a lot of money here. We all feel really confident that this case is really strong. These defendants are at fault. We're going to win and serve justice and make a lot of money. Even when you know that, those deals do not get done in 2 weeks. Everybody asks, can I have the money in 2 weeks? No, you cannot. Right. For the most part, you cannot. These deals generally take between 3 and 6 months. I think, is it possible to do it quicker? Yeah, on occasion, an outlier deal can get done faster than 3 months. Is it possible it takes longer than 6 months? Yes, Ted and I can both attest personally to the fact that we have had deals on for a year.
That closed, yes.
That closed, right. Still, it can take a long time because they're complicated. These are complicated transactions. They involve a lot of parties, right? Especially if you have an insurance party, right? You have the law firm, you have the claimant or claimants, you have the fund, you have the insurer, you have the insurance broker. There are a lot of parties, a lot of cooks in the kitchen.
And sometimes multiple insurers even in the tower. And so
multiple insurers.
Yeah. And so I think our sort of message on that is that insurance doesn't make it easier because these deals are difficult, but sometimes there are opportunities where, depending on the law firm, the claimant, that piece, can kind of work well together. But, the biggest kind of message is always, when litigation finance started, it was so expensive because the risks were one party was holding the entire bag, right? And, you're holding basically an illiquid asset, and there is really, no way to judge duration with any, like I remember when we started, people would say, we're going to file here. And I saw in Lex Machina that the average time to trial is 2 years and 1 day. And I said, but that includes all the cases that get filed pro se and were dismissed in a week, right? Oh yeah. And how many of that? Oh, I guess that's 35%. No. How long do the antitrust cases with class cert take? Well, they take 2 years plus 8 years plus 2 years of appeal. But I think that just because the deals aren't easy to do doesn't mean they're not worth doing. So, one thing, and I really don't want to talk about regulation or taxes or any of that kind of stuff. But I think it's fair to say, but I want to get your thoughts on this. In my view, demand for this money amongst all layers of law firms, including the most sophisticated, in my humble view, is off the charts because people see that it's an attractive financing tool. So can you talk a little bit about where, where you're seeing people, like what corners of the world are people coming to you looking for money?
Sure. The most sort of convenient story that also has the benefit of being true is that people seek litigation finance because they can't afford to bring their lawsuits. And they have meritorious lawsuits that should go forward. There's been some kind of injustice, and people, deserve to have their rights, recognized and paid for. but they can't afford it and without litigation finance. So that is one, access to justice argument that is very real. And one really important reason why people seek litigation finance.
And Rebecca, are you seeing parties that don't have money, okay, so they can't afford it, get sophisticated capital to pay for bogus stick-up cases and then are getting paid? No, I'm just asking,
yes, no, absolutely not. Absolutely not. One thing I tell, and Ted, you know this because I say it every time we talk to a new borrower, is, people sometimes come to us and they really know almost nothing about litigation finance, even if sometimes they've heard of it, they have a general understanding of the concept, but they really know nothing about it. And I say to them, if you want to put yourself in the shoes of a litigation funder, all you have to do is think about the most economically rational way of thinking, and you will be in their shoes. There are very few sort of competing interests in a litigation funder's view on an investment. Really, at the end of the day, all they care about is, if I put money into this investment, am I going to get this money out? Will this case win? Will this defendant pay? And how long will it take? Those are the only things that litigation funders care about. It is super, super economically rational. And there is just no way that routinely litigation funders would put their money into matters that will not return capital. There is just no way. Do people make mistakes? Are these litigations risky? Do sometimes we think that they're going to win and return capital and then they don't? Yes, that happens. It happens regularly, as a matter of fact. But the reality is nobody is doing that on purpose, because that defeats the entire economic rationale of these funds. So no, non-meritorious claims are not getting financed. It would make absolutely zero sense.
Right. So let's go to non-meritorious, because I want a rule for everyone talking about this industry. So first of all, you go to your lawyer in any matter, right? Any matter. The highest a lawyer is ever going to tell either side is your 80% chance you're going to win, because there can be a legal error by the judge. There could be a juror who wasn't like you. So can we all agree that if a case loses at trial, that does not necessarily mean that it was not meritorious? Can we agree on that? Will you agree? You'll take that?
Yes,
okay.
I agree.
Okay. And then will you find any defendant who gaslights the press for decades about their product to ever admit that their defenses were frivolous for decades after they lose jury? We're not going to see that this year. That's not a big prediction.
That is not in my 2026.
Deny will stay out there.
Yeah. I mean, of course.
But that's economically rational, right?
And it's commercial. I mean,
hey, hire me as the CEO of a company that sold asbestos-laced products. I can't admit that. That's not good for my shareholders. Okay. So let's go to this is another one I ask everybody because I think it is good. You are very plugged in. You speak at conferences. You're on mega podcasts. You're also on this podcast. So like you're in ether though, but what do you think is like one of, or not like one of the big like misconceptions about this business?
Yeah. I think people really don't understand the value that litigation finance brings to the justice system itself. It's not just about, as we were saying before, right, access to justice. That is important, and that is a strong element of this industry. But it's also, like everything else in our capitalistic economy, it is also allowing parties to have access to capital as a tool in their financial tool belts in promoting their businesses. When you think about it, right, historically, every business has been entitled, if they want to take out a mortgage to buy a piece of real estate. That is standard business practice that is fundamentally baked into our economy. But historically, because, the legal profession has been sort of touted, and it is, I have so much respect for it. I'm a lawyer, you're a lawyer. I mean, it's hard to become a lawyer. It's hard to be a lawyer. And it is, we do hold ourselves as attorneys to a higher standard, both because we just do innately, but also because we have taken oaths and we have taken the bar and we have studied very hard. And we have to. We think of ourselves as professionals and serving, the community. But the reality is it's a business, and nobody can practice law if they also cannot put food on the table for their families. And
it's not, it's not, the defense bar isn't volunteer.
Can you believe it?
Wait, the motion to reconsider, the motion for reconsideration, they charge for that?
Can you
I thought they just wrote that.
I know, right?
And then the en banc petition, or no, that wasn't free, Rebecca. I'm telling you, norms have been shattered on this podcast. I'm telling you. Wait till the world hears this.
News.
Oh my God. I know, breaking news. Right? That's right.
So I just, it's only fair that law as a business has access to the same capital as all other businesses do. I don't think, I think the idea that the defense bar likes to push out is that, litigation finance somehow makes attorneys who use it unfair or unprofessional or unethical. Is that just, it doesn't have any basis in reality.
But the more time talking about how the lawyers are financed is less time talking about the price fixing, the asbestos sales, the cancer you caused, the fake bankruptcies, right? Yeah, it's just look at this shiny object. I'm going to add one more thing.
Please do.
If we live in a common law system, do we want only one side of the V with good lawyers? Right? Do we want bad law to be made because people can't afford? For example, I was an antitrust lawyer, and some of the worst law would be made when there would be a garden variety contract claim, and someone would say, "Oh, antitrust says treble damages. I'll also say it's an antitrust violation," right? And they get rightfully whacked, right? It goes out, and so bad law is made. So if we're going to live in a common law system, shouldn't we hope that both sides have the very best advocacy so we get to the right binding result that not only decides the dispute between the parties, but for example, let's say there's a question of, is California pattern jury instruction 5, is that proper, right? Well, guess what? Wherever that falls, the next trial has to go with, right, jury instruction 5. Do you want one overworked lawyer and then an army of people being paid by insurance on the other side? Probably not. I mean, actually, well, maybe you do, depending what you think about jury instruction.
You're on. Yeah, I mean, but that's the reality. I mean, here's the truth. I love America. I'm a patriotic citizen of this country.
Hang on a second. Wait, that's the takeaway. America lover Rebecca Berrebi joins the podcast. Okay.
I am a patriotic citizen of this country. I also know that our government has a lot of issues and our judicial system is broken. And the reality is litigation finance is a tool that can be used to help navigate what is fundamentally a broken system. Litigation finance did not break the system. The system was already rigged towards people with money. That is just the truth.
If it wasn't unaffordable,
this industry is just a response to the reality that the system is broken. It is statistical knowledge that the party with the most money wins. I mean, it's unfortunate. It does not feel comfortable. And I don't think a lot of people want to say it, but it's more often than not the reality. And so why shouldn't the plaintiffs have the same access to capital that the defendants do? It just makes perfect sense. And that's why I really, truly believe, and we're not going to talk about regulations and the law, but the reality is this industry is going to remain in existence no matter what regulations are put on it. And that is because there is demand for this money.
There's capital need. There is capital need.
There is a need for it. And you will find as an industry ways to provide that capital within legal boundaries, because because everybody wants it. The claimants want it. The companies want it. The law firms want it because it allows them to take on great cases.
Right. Okay. Well, I can't let you go without asking you, because I think there is a really great organization in the business, and I know that you spearheaded it. So could you tell everybody, and of course, I'm going to put the hashtag in and maybe they'll all listen to, but can you tell everybody about Wolf and what's up with Wolf for 2026?
Yes. So Wolf is Women of Litigation Finance. We have been going strong since 2019. And we have a really excellent active membership. Our mission is really to bring the women of litigation finance together in a supportive community where we don't exclusively talk about women's issues. To be clear, we talk about industry issues, and we support each other in our businesses and professionally. So I encourage women and men to join Wolf. One way you can do that is by finding us on LinkedIn and joining our LinkedIn page, and you will have access to all of the updates and information about all of our events. We actually have a town hall event coming up, and we will start advertising it soon. And I really should have confirmed the date before I got on this, but I believe
you're like the actor on TV. It's like, oh, my publicist forgot to tell me when my movie comes out.
God.
Is it next Friday?
I'm fired after this.
I don't know. Yeah.
Clearly, I'm not paying them enough. But I believe it is March 5th at 2 p.m. Eastern. But obviously, log on to our LinkedIn page and you will have all the updates. We have such exciting things happening in 2026. We're always having events. We encourage everyone to participate and join. It is a very worthwhile membership, and it's been thrilling to work with all of these incredibly bright people who are doing things on the cutting edge of this industry and beyond.
All right. So Rebecca, somebody wants to hire you. Where do they find you? LinkedIn, website? What do you think? Best way to get in touch?
Best way to get in touch. Anyway, we are very accessible. I love LinkedIn. We respond to LinkedIn messages. We respond to emails. Our website is litfinadvisors.com.
I'll put it in the notes. I'll put it in the notes.
Perfect. Yeah. And we are happy to schedule times. We're also happy to take calls on the fly. We respond to texts. I mean,
we do it all.
We make it pretty easy. We love, as you can tell from this podcast, we love to talk.
Yes, maybe, and we'll listen. We promise we'll listen. Okay, Rebecca, really great to have you. Thanks so much, and we'll talk soon.
What a pleasure. Thank you.
Thanks.